What if I told you that calling your ex, or soon to be ex, high conflict could actually make the judge think that you're the high conflict one? Even worse, what if the evidence that you're presenting that you think is so strong, so persuasive, so good, proves the high conflict is coming from your side? That you're the one creating the problem, that you're the one making the case high conflict. Well, I know it's confusing, but if you want to know what I'm talking about, stay tuned because I'm getting into it today.
Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
Hello there, it's Tracey Bee, and you're listening to another episode of Self-Represented in Family Court. And today I wanted to talk to you about high conflict. I think it was a week or so ago, someone mentioned that their soon-to-be ex was high conflict because they refused to give that person, that parent, the information regarding travel for their children. The parent that was complaining had mentioned that there was no court order, or there was a court order, but it didn't specifically state that the other parent is to share that information with them. And so there were other people automatically labeling that uncooperative parent as high conflict. And if you know me, you know that I am always suggesting to people that they refrain from using certain terms or certain language, even though it's mentioned, it's discussed, it's thrown out there everywhere. Certain terms, certain lingo, certain legalese, certain phrases, certain labels should not be used in court, especially in mediation, in discussions, in court for sure. Because a lot of times when certain words are discussed or mentioned in front of a judge or any other key player, they automatically think that you are the one who's been plotting, who's been manipulating, who's been calculating things, and that's why you are aware of certain terms to use. And of course, as usual, I got a lot of flack from other people saying, well, this scenario happened to be dad that didn't want to provide that information. He is high conflict. Anytime a parent doesn't want to co-parent, that makes them high conflict. And for me, I don't agree. And I know that my perspective on things usually varies especially from lawyer represented litigants, but definitely from pro se litigants as well. Because lawyer represented litigants, sometimes they have that conduit, they have that messenger of a lawyer who will explain to them why or my perspective. But when you're pro se, a lot of times it's hard for you to fathom where I'm coming from. Let's start off with what high conflict may not be. Someone who disagrees with you. Someone who disagrees with, your interpretation of a clause, your understanding of a judge's directive, your interpretation of a law or a rule. Your disagreement or your difference in opinions or perspectives does not necessarily make the other party high conflict. So if you're in a position where they just won't agree on something, it could be reasonable, it could be unreasonable. They just don't agree. Ask yourself this question. Are they creating conflict? Or do they simply just have a difference of opinion or a different position than mine? That'll help you sort that out for sure. How about someone who's enforcing their rights? That's not necessarily being high conflict, because the same can be said about you when you're enforcing your rights. Does that make you high conflict? Absolutely not. So ask yourself this question. Are they creating unnecessary conflict, or are they just attempting to enforce an agreement, an order, or entitlement? A high-stakes case. A case can be contentious without being high conflict. Did you know that? Yeah. There's some cases that are inherently contentious, like relocation cases, business valuation cases, hidden asset cases, domestic violence or abuse cases. Those cases are usually just contentious, doesn't necessarily mean high conflict. And now when I say that, I don't mean from the court's perspective, I mean from your perspective, because the court is going to use its own gauge, its own way of discerning whether or not someone or something is truly high conflict. So in that scenario, you're going to ask this question. Is the conflict being driven by the people or by the stakes? Is it by the person, the other person, the soon-to-be X or the X, or by the stakes that are involved? Because the stakes alone can be so high, so serious, so important that just that alone makes the case very contentious, which can be high conflict, and there may be instances where it's not. How about instances where there are boundaries in place? Boundaries are being enforced, boundaries are being crossed, boundaries are being ignored. Things like refusing to communicate outside of a parenting app, insisting that communication stay child-focused, refusing verbal conversations at all times. Those things will have someone say, boy, they are so impossible to deal with. No, they may not be. They may just be really intent on covering their behinds or just documenting things accordingly, or just for their own purposes, just keeping track or keeping the contention down to a minimum by insisting on minimal communication or other means or other methods of communication. So ask yourself this, is that person being difficult, or are they just refusing to participate in unhealthy dynamics that they've maybe put up with before? Every no isn't a conflict. Sometimes it's just a boundary, and we all have them, or we all should have them anyway. How about, this is a good one. How about emotional reactions during those tough times, during those challenging moments? You may see crying, anger, hypervigilance, emotional messages being relayed. These things do not necessarily make that person high conflict. Again, a person being high conflict, you calling them high conflict, and your case being high conflict are not necessarily synonymous. It's important for you to know that. And the difference is the court is going to determine what it deems high conflict. You see, when you label the other parent, the other party as high conflict because they're uncooperative, as I said, you'll go into this thinking that way, and that's the energy, that's the impression you'll give off. And even though they may certainly be that, for you to walk into an environment that's conducive or it's intended to facilitate settlement or its resolution, then you come off as the one that is, as I mentioned, high conflict. So let's talk about what high conflict situations look like. The endless accusations, the unnecessary emotions, the last minute emergencies, the refusal to follow the rules or follow the agreement, just the drama, just the chaos, the constant manipulation and the plotting and the controlling. Yes, those are all high conflict, but it's very contextual. Because someone comes to you and says, hey, let me tell you what's been going on. My soon-to-be ex or my ex has been doing this and has been, exhibiting these behaviors of high conflict, doesn't mean that's necessarily the case. It doesn't mean that they're not doing these things. It doesn't mean that it's necessarily arisen to the level of being high conflict. High conflict in a sense where we're talking litigation, we're talking stagnation, we're talking undue delays, we're talking legal fees running up, the gamut. We're talking about things that surround the scenario, the situation that from the court's perspective looks like it's going to be a long drawn out battle where negotiations and or settlement seems almost impossible, almost out of sight, almost, just not doable. And so if that's the case, sometimes the court is going to take a different approach to you. So saying someone is high conflict for doing these things, they may very well be high conflict. They may very well be, but everything is contextual. What do I mean by that? Well, we don't know what that person who's complaining or who's labeling the other parent as high conflict, we don't know what they've done to instigate or to antagonize or to incite that person, that their response or their reaction. And so to say that their reaction or even their action is high conflict without context, to me, is no better than calling someone, accusing someone of having mental health issues when you're not a doctor, or calling somebody a narcissist and going to court and telling the judge that they're a narcissist without having a clinical evaluation or observation to support that position. High conflict, or calling your soon-to-be ex high conflict, and I know there are lawyers who will say that. So a lot of you are just mimicking your lawyer or your coaches or your mediators or your therapists. I totally get it. But again, for me, for you to actually take that position and for you to go into any environment, whether it be mediation or just a meeting with attorneys in the other party or court, for you to take that position, going into those environments with that mindset can actually do more harm than good. It can. So let me tell you how you should identify high conflict. It may be the parties, it may be a party, it may in fact be the issues. It may be the stakes. It may be the other things. It may be all of those. But my point is, you calling the other party high conflict and the court seeing your case as high conflict are not necessarily the same thing. It's important that you understand that. That's why I'm talking about this today, because a lot of you are getting the two confused, very confused. To me, it's no different than going to court. Someone asked me the other day, should they use the N-word, the narcissist, accusing the other party of being a narcissist in their petition? And it was interesting, and I'm bringing this up because when we discussed her petition previously, I made it clear that she should not be using those terms. And then a few days later, she messaged me and asked me, should she use the term in her petition? And I said, absolutely not. We discussed this. You can always describe the observations you've been making or you've made about the other party, their behavior, their antics, whatever. But to use the word narcissist, it indicates to the court that you might be the problem. You may be high conflict. And so let's talk about it now. Let's talk about what the court might see as high conflict. Conflict that follows you everywhere. You're the one constantly complaining. You're the one constantly ignoring, denying, being uncooperative, not listening, wanting to overtalk, insisting, persisting, Yeah, those are the things that judge will or could label you as the high conflict. Cases that escalate, or because a party escalates the case because they don't like the way things are going. They haven't tried to resolve anything. They just immediately escalated the case to court. Yeah. Judges want to see attempts at resolution without getting the court involved. So if the judge asks you or the other party if those attempts have been made and the answer is no, the judge might instantly label you and your case as high conflict. Every problem becomes a crisis. Every problem warrants an emergency motion or a call to the judge, or, there's always something to mention at every update, every status conference, in every motion. Yeah. Chances are judge gonna see you as the high conflict one. You want to point the blame at somebody. You always want to point the blame at somebody. You just can't just state the facts objectively and wait for the judge to make a ruling or make a decision or impart their opinion or their authority. Everyone has to be an enemy. Yeah, chances are you are, and you're making your case come across as high conflict. You reject all solutions. You don't even offer a solution. You just constantly complain and make demands and make requests and make this and make that and make this and make that all day long. Well, not all day long, but every time you go to court. Yeah. Judges probably labeled you and your case as high conflict. I'm sure. A person is not necessarily high conflict when they hire an aggressive attorney, or when they don't agree, or when they want what they want, or when they want more support, or when they want to just get their point across, or when they're assisting on discovery or information that they need to make informed decisions, or when they document everything. That's not necessarily high conflict. But when you start doing things where the court is thinking you're going to make this case drag on longer than it should, you're going to make these court appearances more complex and more convoluted than they need to be, and you're going to require extra services, extra key players to get involved, chances are the judge or the court have labeled your case as high conflict. So, I hope you don't do that. I hope you've learned something from this episode. I hope that you will take this information, reassess, reevaluate, reposition, and represent your issues, your argument, and your case in a way that it does not come across as you being the high conflict one. Anyway, if you want to talk to me about whether or not you are presenting your case or making your arguments as if you are the problem, hey, let's do that. Set up a meeting. We can do an hour. We can go through everything. I don't give legal advice, but I give something better. I give you some strategic advice, some strategic insight so that you know what's going on and you know what to do to move your case forward. If you're ready, let's do it. The link is in the show notes. And by the way, the next 2 weeks are going to be the last few weeks of new episodes of the podcast. For the month of July and August, you will hear some of the most listened to, most popular episodes being replayed. So I'll be taking a break. But you can, if you're in Northern New Jersey, you can meet me every Wednesday at different locations in Bergen, Essex, or Hudson County to have a discussion about strategy in your case in person. Yes, in person. I'm taking my office hours Wednesday and I'm bringing them to coffee shops throughout Bergen, Essex, and Hudson County for the month of July and some of August. So if you're interested, feel free to email me at divorcecoachesq@gmail.com and I will add you to the WhatsApp group so that you'll be getting updates about where I will be. I will be every Wednesday, except holiday Wednesdays, at a different location, a coffee shop, because I want to support small businesses, at a coffee shop anywhere in Essex, Hudson, or Bergen County on Wednesdays. So that I'm talking anywhere between 11 a.m. and 2 p.m. every Wednesday through July and August, so we can discuss strategy in your case. So if you're interested, feel free to reach out to me. Email me at divorcecoachesq@gmail.com, and I will add you to the WhatsApp group so that you are aware of the location each week. So in the meantime, though, please tell anybody you know who's self-representing to come and tune in, because they're going to learn exactly what they need to move their case forward. Thank you so much for listening. I appreciate each and every one of you. Until next time, bye.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.